Thank you, Deputy Speaker. And almost every time I am on my feet in this place, I bring in notes expecting to stick to the script and never do, but today I plan to. Because this is a very important bill, the Justice Legislation Amendment Vicarious Liability for Child Abuse Bill 2025. It's important and necessary in restoring justice and certainty for survivors of child abuse in Victoria. And at the heart of this bill lies a simple truth, that no child should ever be abused and no institution should ever escape accountability because of a legal technicality. When abuse occurs within the authority, power or trust placed in an adult by an institution, that institution must be answerable morally and legally. This bill exists because the High Court's decision, as we've heard from many members in this place today, Bird v DP last year, fundamentally disrupted what had been, up until then, an accepted approach to institutional liability for child abuse. Bird v DP held that a Catholic diocese was not vicariously liable for the criminal acts of an assistant priest because he was not technically an employee. And I think I've heard just about every member who's spoken on this bill talk about that case today. The High Court rejected the akin to employment doctrine previously applied by Victorian courts and stated very clearly that any reform to this area must come from the legislature, and here we are. That moment, in practical terms, closed the doors of justice to many survivors. Many matters stalled, many are ongoing. I was talking to someone yesterday who has been involved in a case that's been caught up in the High Court for 6 years now. Others have been settled prematurely for far less than was fair, out of fear that their claims would be dismissed with costs, and institutions that until then operated on the understanding that they were accountable suddenly found themselves sheltered by a very narrow technical interpretation of employment status. So this Parliament should not and cannot allow accountability for child abuse to turn on whether a person was an employee or an office holder or a contractor or a subby. Survivors deserve better than that. They deserve consistency, fairness, and a pathway to justice that cannot be derailed by organisational structures designed decades ago. So this bill does two things. It amends the Wrongs Act 1958 to create a clear statutory framework for vicarious liability for child abuse, and it applies to all child abuse, past and future, and ensures that liability extends not only to employees, but also to people who are akin to employees. And this reflects the reality of how many institutions actually operate, particularly religious organisations, community groups and schools where authority, trust and control are not limited to those just within the formal employment contracts. Second, it amends the Limitation of Actions Act 1958 to allow survivors impacted by the Bird window, which was that period between the High Court's decision in November of last year and the commencement of this legislation, to have their settlements reopened or judgments set aside. And this gives survivors whose cases were unfairly weakened a chance to come back, start again and seek proper redress. And in doing so, the bill restores the legal position that most survivors reasonably believed existed prior to Bird. And frankly, it restores faith in the Parliament will not stand by while a sudden change deprives survivors of justice that they've fought for years, if not decades. There was some areas of concern, though, throughout stakeholder engagement with this bill. One of those was the retrospective aspect of the bill, and yes, it does contain, as the member for Euroa said, it does contain retrospective elements. And in most circumstances, retrospective legislation probably isn't most desirable. It offends the rule of law, but this is not ordinary. These are not your ordinary retrospective elements. This Parliament has, for many years, recognised that child abuse is an exceptional class of wrongdoing, and it absolutely is. There's already been moves to remove limitation periods. There's been past settlements that have been open where injustice was evident, And this is because of the nature of abuse and the trauma that it inflicts, and it demands that we centre justice for survivors above administrative convenience. As I said yesterday in this place, Deputy Speaker, some things just transcend politics, and this is one of them. So the retrospective element here is narrow, it's time limited and necessary. There was concerns about the akin to employment test, which it's true this area has been difficult and evolving, but it's precisely why statutory guidance is required. This bill gives courts a framework but preserves their discretion, so it doesn't freeze the law, it offers guidance, and it reflects the lived reality of institutional abuse, quite frankly, where perpetrators often operate with authority, trust, as I've said earlier, and access regardless of what their contract says. And independent contractors was also one that raised some red flags and also concerns from religious or community organisations. And as I heard the member for Euroa speak about earlier, some have suggested that this bill was going to create unreasonable burdens on churches and charities. And as my good friend and colleague, the member for Euroa, stated, the real burden here is on survivors. It's a lifelong burden, and it's one they live with every day. So please don't come at this with concerns over burdensome admin. What an absolute joke. So accountability is not an attack on faith or community, it's an affirmation or reaffirmation of our shared moral responsibility, especially in this place, as legislators, to protect children. So we are not opposed to this bill. The Liberals and Nationals have supported reforms that empower survivors and ensure institutions cannot evade responsibility. So this bill will restore justice disrupted by Bird. It codifies an area of law marked by uncertainty and the ability of the role to create situations of intimacy or vulnerability. Now, there are a number, obviously, of aspects to this bill, but as I've said and as I've heard many people talk about in very considered contributions on this bill today, this has come about because of a really unfortunate legal loophole that has been found and has traumatised survivors of institutional child abuse. And that is not fair. So we have an obligation to consider this at its core, not a partisan issue, it's a moral one. Children were abused, we know that. Institutions failed them, we know that. And when the law creates that loophole, then we have to, it's our responsibility to close that gap, and that this bill will do exactly that. Survivors of child sexual abuse show extraordinary strength, despite the challenges. Many spend decades trying to come forward. Many stay silent because talking about that trauma is too hard. Oftentimes, talking about trauma is just too hard. I get it. When they finally seek justice, the last thing they should encounter is that legal loophole that tells them your abuser was technically not an employee, so the institution can't be held responsible. Can you imagine? Every member in this place knows, or at least should know, how deeply wrong that would be. Institutions hold great power, Deputy Speaker. And with great power comes great responsibility. And when institutions enable environments where abuse can occur or place adults in positions of trust, intimacy or authority over children, they must be answerable to that. The High Court made it clear that it is now up to us, and we are doing that today. This legislation is what will decide what accountability looks like, and the bill articulates that responsibility clearly, consistently and justly. And it is necessary and it is justified, and most importantly, it will help to restore fairness to those who've already suffered far too much. Ultimately, this is about delivering justice, real justice for those who deserved it decades ago.